Good evening. First of all, I thank the organizers for having provided me this opportunity to interact with you. I stress the word interact with you. This is not an attempt to teach you something new, but to share my views, thoughts, or experience which I have gained over the years with you, and also to gain some information or knowledge from your side also. So try to make it as interactive as possible instead of it being a class by me. The topic chosen for the day is drafting of writ petition. I need not tell you what is a writ petition or what are the different reliefs which can be granted by the High Court under Article 226. My attempt will be to share with you certain insights or certain tips for drafting a writ petition to be presented before the High Court, especially our High Court. If you are asked, what is memorandum of writ petition? Can anyone tell? What is a memorandum of writ petition? It's a pleading which we file before the court. Pleading before the court is generally known as an art of presenting. Please listen. It is an art of presenting grievance of a person before the court. Art of presenting grievance of a person before the court in written format, in a systematic manner, in a coherent manner, infused with legal grounds and prayer for relief. Hope you got the point. First of all, it is an art. Presenting your grievance, legal grievance, before a court in written format, arranged systematically, in a coherent manner, and infused with legal grounds with a prayer for relief. Or if there is any mistake, you can correct me. So, in our High Court, we follow the pattern. It's statement of facts. Grounds. In ground portion, we infuse legal contentions. And the third part and the last part is the prayer portion. Pleadings are submitted in written form. We supplement the pleadings by way of arguments. It's oral arguments, that is altogether a different portion. We are here dealing only with the pleadings filed before the High Court in the form of a writ petition, and other pleadings, counter affidavit and reply affidavit, which we are not dealing with today for want of time. I said pleading is an art. For every art, there are certain set of tools. Am I right? For example, a painter, paint, brush and canvas. A person with inherent talent, or a person who has cultivated or acquired talent in painting over the years by experience, by practice and by dedication, can do wonders with these three tools. If the same tools are given to me, I will say I will cut a sorry figure of myself. Similarly, some documents are given to you or given to me, or some layman who has no legal background or backing. He may not be able to file it in a proper manner with legal grounds and attaching the required documents and pleadings. So the tools are same or the materials are same. But by experience, by practice, and by dedication over years, we lawyers acquire some kind of knowledge in the field of law and in the field of filing a writ petition and presenting it in a proper form. Then I will take you to the next part. For every pleading, there are essentially two components. One is the legal part, so one aspect. The other is language part, or language part and legal aspect. As far as language part, no one can help you except you yourself have to improve it or cultivate it by reading various books, judgments, and books on legal literature. As regards the second part, that is the legal aspects, we lawyers or teachers, presence of some of the senior members of the bar is in fact really intimidating. Because they may sound that I am trying to teach them some basic things. That's a difficulty. So you have to cultivate command over language, excellent command over language, which is absolutely essential for any better drafting. Then mainly we will deal with the second part, that is the legal aspects. Before we go into different kinds of writ petitions, there are certain general norms or general principles which we must understand with reference to the constitutional provisions as regards writ petitions in general and the certain bar that the Constitution itself provides in the Constitution. First is Article 12. Normally these Article 12 and 13 are not given much importance in the college syllabus, but when you come to the practice, Article 12 and 13 have vital significance. What is Article 12? State. Do you have a copy of Constitution, anyone? Article 12 defines the term state. That definition is for the purpose of Part 3 of the Constitution, Fundamental Rights. In this part, unless the context otherwise requires, the state includes the government. It's an inclusive definition. Government and Parliament of India and government and legislature of each state and all local or other authorities. So state, Parliament, local authority or other authority within the territory of India or under the control of Government of India. So the definition of state takes in government, parliament, local authority, other authority or institutions. There are certain authorities which are constitutional in nature. As you are aware, one election commission, public service commissions constituted under Article 315, CAG, Finance Commission constituted under Article 280, National SC/ST Commission constituted under 338 and 338A. These are constitutional authorities. Certain authorities are constituted by or established under the statutes. That difference, authorities constituted or established under the statute or authorities registered under the statute, this has vital significance when we file a writ petition, because we have to seek relief against an authority. If client approaches you that I want to file a writ petition against so and so authority, first of all you have to find out whether it is a statutory authority or a constitutional body or an authority registered under an act. I will explain it with reference to certain statutory provision. Statutory authority One, for example, RBI, Reserve Bank of India, is a statutory authority. Kerala Water Authority, KSRTC, constituted under Road Transport Corporation Act. Kerala Finance Corporation. Kerala State Electricity Board was initially a statutory body constituted under the Electricity Supply Act. Now it is a company registered under the Companies Act. After the 2003 Electricity Act, a new company was formed and it is registered under the Companies Act. So certain authorities or institutions which I referred to earlier, KSRTC, KFC, Water Authority, these are bodies constituted by the Act. There are certain authorities, KSCB, it's not an authority constituted under the Act, but it is registered under an enactment. Societies registered under the Societies Registration Act. Similarly, cooperative societies registered under the Cooperative Societies Act. They are companies registered under the Companies Act, societies registered under the Societies Registration Act of 1860, or societies registered under the Cooperative Societies Act. They are not statutory bodies, but they are bodies registered and regulated under the statutory bodies, statutory enactments. Why that is significant? Because you can seek a writ of mandamus, or you can seek quashment of an order passed by such an authority only if it is an authority as contemplated or as defined under Article 12 of the Constitution. Recently, there was a case which went to the Supreme Court from our High Court, that is Muthoot Finance case. Writ petitions were filed before the High Court. Those writ petitions were dismissed. The contention was that Muthoot Finance Corporation is regulated under the provisions of the central enactment and rules and regulations. Our High Court dismissed the matter, and the matter was carried in appeal before the Supreme Court. The judgment is reported S. Shobha, SHOBHA versus Muthoot Finance Limited, 2025 SEC Online Supreme Court 177. The judgment by Justice Pardiwala. There, Justice Pardiwala had held, I will just read two paragraphs. A body, public or private, should not be characterized as amenable or not amenable to jurisdiction. The most important and vital consideration should be the function test. I stress on the point, it is the function that matters much rather than it's a private body or a statutory body. If it is a statutory body, no doubt writ will be maintainable against it. For example, I already told you KSRTC, KSCB, those are KSRTC, Water Authority, KFC, those are statutory bodies. You can maintain a writ. But bodies registered under the enactments, you can maintain a writ only if the functional test meets the requirement of bringing that authority under the state in as much as it discharges certain public functions or duties. So, paragraph 9 of the judgment in Muthoot case. For issuing a writ against a legal entity, it would have to be an instrumentality or agency of a state, or should have been entrusted with such functions as are governmental or closely associated therewith by being of public importance or being fundamental to the life of the people and hence governmental. Writ petition under 226 of the Constitution may be maintained by state government, authority, statutory body, an instrumentality or agency of the state, a company which is financed and owned by the state government, a private body run substantially of state funding, a private body discharging public duty or positive obligation of public nature, a person or body under liability to discharge any function under a statute to compel it to perform such statutory function. As far as the first four limbs of this judgment, there need not be any doubt at all. The dispute may arise if it is a private entity or a private person. You can maintain writ petition against a private body registered under the Companies Act or a Cooperative Societies Act or a private person only if they are discharging Some that area it's clear. Basic judgment is Ajay Hasia case of 1984. I'm sorry, 1981. There the Supreme Court said there are different, one is functional test, the function they are discharging, the control of the state, whether the state has pervasive control, administrative or financial control over the institution, it may fall within, if state has such pervasive administrative or financial control, such an institution may fall within the sweep of state for the purpose of Article 12. But there is an exception to this general principle, which you are all aware. Habeas corpus writ petition need not be against a public authority, even against a private person. If he is keeping a person in captivity against his will, curtailing the liberty, you can move a habeas corpus petition. There he need not be any public authority or state or such other authorities. Then Article 13, 1(3). Article 13 says, laws inconsistent with or in derogation of the fundamental rights shall, to the extent of such inconsistency, be void. So when we challenge a legislation, plenary legislation, or a subordinate legislation, rules, regulations, or schemes framed under the statute, or we are challenging a government order declaring a policy, or a decision taken by the government or governmental agencies, if it is in conflict with Part 3 of the Constitution, Article 13 says it shall be void to the extent it is inconsistent with the fundamental rights. That is very important, because when we challenge many of the legislation, subordinate legislation, government orders on the ground that it violates fundamental right. So if an order or a decision of the government is in conflict with fundamental right, it is void by virtue of Article 13. Then Article 32 is the right of a person, which Article 32 itself is a fundamental right of an individual to move a writ petition before the High Court when fundamental rights are violated. Then Article 71, I am referring to Article 71 only to point out that certain elections, certain proceedings relating to elections could not be challenged before the High Court or even before the Supreme Court in a writ petition. For example, 71. Election of the president cannot be challenged in a writ petition. Similarly, under Article 105(2) of the Constitution, you cannot bring a legal proceeding against a member of the parliament for the action or the something which he has spoken inside the parliament. Then 226 offers the power of the High Court to issue various writs. Then Article 300. Many a times I see writ petitions in which state is impleaded as Government of Kerala or Union of India is impleaded as Government of India. When you challenge, when you seek a relief against the state government, you must implead State of Kerala or State of Tamil Nadu as respondent. Similarly, when you want a relief against the central union government, you must implead Union of India. This is because of the specific provision in the Constitution, Article 300. The Government of India may sue or be sued by the name of Union of India, and the Government of State may sue or be sued by the name of the state. So, in any writ petition challenging governmental action, you must implead the state, government, not Government of Kerala, but State of Kerala represented by so and so. Then certain Constitution itself bar proceedings in respect of certain elections. I have already told you that is 329, bar to interference in electoral matters. Then 343O with respect to election of panchayats, 243ZG with respect to election of municipalities, then 363 disputes arising out of certain treaties are also cannot be subject matter of challenge in a writ petition. Then can we implead the president or governor as respondent in a writ petition when you are challenging a government order or a legislation? All government orders are executed in the name of governor. By order of the governor, കണ്ടിട്ടില്ലേ government ഇതിൽ office memorandum ആണെങ്കിലും central government ആണെങ്കിലും under the authority of the president such orders are issued. Who gives the final assent for a bill? Governor or president as the case may be. So when we challenge a legislation or a government order, is it permissible under the constitution to implead the governor or president as respondent? Any constitutional bar? There is a constitutional bar, Article 361, protection of president and governors. That is why we cannot implead governor when you challenge an order of the government. But governors also exercise some statutory power. Similarly, president also exercise some statutory power. President of India is the visitor of almost all national universities and IIT, NIT, those institutions of national importance. President is the visitor. When president issues an order, in his capacity as the visitor of a university and not as the president of India, writ petition may be maintainable against him. Similarly, in our state, for us, except Nuance, for all other universities, for Nuance the Chief Justice is the Chancellor. But for other universities, Governor is the Chancellor. He is the Chancellor by virtue of the provisions in the State University Enactment, not on account of his as a constitutional letter under the Constitution. So when writ petitions are filed against Governor in his capacity as a Chancellor, definitely Chancellor can be made a party. Recently we had an occasion. State filed a writ petition against last year. Not against the Governor, we have not filed any writ against. We filed a writ petition challenging the orders of the Chancellor. Hope you got the difference. But one judgment you may have to work up, that is State of Punjab versus Governor of Punjab. When the Governor of Punjab did not grant assent to the bills passed by the Legislative Assembly, they filed writ petition before the Supreme Court. The cause title is this: State of Punjab versus Governor of Punjab. Whether this is permissible in the light of Article 361. 361 says, I don't know why that contention was taken or why it was not specifically answered. 361 says, for actions of the governor, you cannot proceed against him. Probably in this case, it is not an action of the governor, but it was an inaction of the governor. Maybe. Still is an area which you have to ponder over and to conduct research on that aspect. Then I will come to the certain points with reference to our High Court rules. A petitioner in a writ petition may be an individual. He may be a partnership firm. He may be a company, statutory authority, and even the government may step into the shoes of a petitioner challenging the orders of some other authorities. When you file a writ petition for an individual, definitely you give the name and other details. When it comes to the partnership, there is divergent views, which you have to research. I will place both the views before you. Some of the lawyers are of the opinion, partnership is not a person. It is an association of individuals. So partnership cannot file a writ petition. Managing partner can file a writ petition, or a partner authorized by the partnership can file a writ petition saying that managing partner so and so company. Some cases, most of the cases we have seen so and so company represented by managing partner. There is difference of opinion whether this is permissible, because a writ petition can be filed either by a person, okay, person or a person and citizen. In certain cases, all citizens are definitely persons, but all persons need not necessarily be citizens. I hope you got the point. All citizens are necessarily persons, but all persons need not be citizens. A foreign national can also file writ petition, but he cannot claim certain fundamental rights. Certain fundamental rights are exclusively for citizens. That is why when bank nationalization proceedings were challenged, along with the company, certain shareholders also joined, because company is not a natural person. Company cannot claim that it is a citizen. Company is an artificial juristic person. Company can definitely, a company registered under the Companies Act can definitely file writ petition, but it cannot claim certain fundamental rights which are exclusively available only to citizens. So if you are challenging a governmental action where the claim can be raised only by a citizen, it is advisable that you implead some of the shareholders or the managing director in personal capacity also as the petitioner, because we must expect a contention from the other side that company cannot claim certain fundamental rights, company is not a citizen, so this writ is not maintainable. You can overcome that objection by impleading either the shareholders or the director board members. Statutory bodies can also file writ petitions. Then, who are the necessary parties? The respondents can broadly be divided into two categories. One is necessary party and the other is proper. You are right. I will explain that also with reference to certain instances. Necessary party is one in whose absence no order can be granted. Necessary party is one in whose absence no order can be granted. For example, you are challenging a government order. State is a necessary party. If an order has been passed by the state, after consultation between various departments, like finance department was consulted, they have expressed certain opinion which you will be able to find from the order itself. You can implead the finance department secretary also as respondent. They are not necessary party, but they are just proper party. Okay. I already told you that when state is impleaded under Article 30, it must be State of Kerala or Union of India as such. Our Rule 148, Kerala High Court Rules 148. If the issue involved in the writ petition pertains to more than two departments, Chief Secretary should be impleaded as officer representing the state. So, State of Kerala represented by Chief Secretary, Secretariat, Thiruvananthapuram, Rule 148. Proviso. Provided further that if the subject matter of the writ petition relates to two or more departments, or if the petition is of such nature, the disposal of which warrants information from two or more different departments, Chief Secretary to the government and Secretary to those departments shall be made as parties representing the government. So, normally what we do, State of Kerala represented by Chief Secretary. Then, if it is an order passed by the Higher Education Department, we will implead Principal Secretary, Principal Secretary to Government, Higher Education Department. And if that order has some financial implications or financial ramification, we will implead Additional Chief Secretary to Government, Finance Department. Got the point? Then, filing of a writ petition against innumerable persons, while filing a writ petition, which is likely to affect the interest of innumerable person, you can file it in a representative capacity. That is also dealt with in Rule 148. All persons directly affected shall be made parties to the petition. Where such persons are numerous, one or more of them may, with the permission of the court, on an application made for the purpose, be impleaded on behalf or benefit of all persons so affected. But notice of the original petition shall on admission be given to all such persons either by personal service or public advertisement. So, for instance, in a writ petition challenging a seniority list, there are innumerable persons who are likely to be affected. We can implead one among them as a respondent. We must indicate, we must file an application stating that so and so, who is the fifth respondent in the writ petition, is impleaded in a representative capacity on behalf of persons who are likely to be affected by the final outcome in the writ petition. And I am prepared to take out notice by paper publication. If the court permits, what would be the paper publication can be affected? It is as good as service to all persons who are likely to be affected. And any judgment passed in that writ petition cannot be challenged saying that I was not heard before passing this judgment. Okay. And when you file a writ petition against university where some urgent orders are required or urgent action of the university is required, it is always advisable to implead the Vice Chancellor also as a respondent. I will tell you the reason. We are filing a writ petition against Mahatma Gandhi University, Kottayam. So, Mahatma Gandhi University, Kottayam, represented by Registrar. Second respondent, Vice Chancellor. Certain decisions can be taken by the university only after convening meeting of the syndicate. Some matters must be placed before the Senate. When it comes to academic matters, academic council meeting may be required to be convened, which is a time-consuming process. So, if some urgent decision is to be taken by the university, court can definitely direct the Vice Chancellor to take a decision. Vice Chancellor can exercise his emergency power, which Registrar cannot exercise, and the matter can be placed before the next meeting of the concerned committee, syndicate, Senate or academic council for approval, ratification, or just it can be reported. Then affidavits in public interest litigation, an additional requirement is there under 146 capital A. I am not reading out. Some additional requirements are, some additional pleadings are there to be in an affidavit filed in support of a PAL. Then CPC is not applicable to writ proceedings, section 141 of CPC. But the principles governing pleadings, CPC can be adopted in appropriate cases, though strict rules of pleadings in CPC as such may not be applicable. Fundamental principles of pleadings contained in the CPC can be extended to writ proceedings also. What is the purpose of a pleading in a case? What is the purpose? We are saying about the pleadings. What is the purpose? It essentially two purposes. Let the court know what your grievance is. Then the other party must be told that this is the point which you have to defend. He cannot be taken by surprise. Sometimes we see in cinema that some documents were taken from the pocket and placed before the court and orders are passed. The other party shall not be taken by surprise. That is the foundational reason for a proper pleading. Then, whether judicial officers can be impleaded as respondents. You are challenging an order passed by a judicial officer. Whether judicial officer can be impleaded. The judicial officer was impleaded and the Supreme Court has suo motu struck off that judicial officer from the party array. Pepsi case 90, this is the judgment. Judicial officer shall not be made parties to the proceedings. judgment by Justice Sujata Manohar, that is Pepsi case 1998, 5 SEC 749. A magistrate was impleaded as the first respondent. Then in a recent judgment, that is Kasi versus Muslim Educational Society, 2016, 9 SEC 263, judgment by Justice Chandrachud, court held tribunal is not a necessary party when its orders are challenged. But statutory authorities must be made parties. Tribunals are not necessary party. Similarly, court or judicial officers shall not be made as respondents in writ petitions. Then we shall move on to the different types of writ petitions. Writ petitions can be broadly classified depending upon the orders which you challenge or the proceedings against which it is challenged. Extent of judicial review in all these cases vary from the order or relief which you seek. I am not referring to the nature of the relief which the court can grant, but with reference to the challenge you make. One is writ petition against constitutional amendment. Then second, writ petition against plenary legislation. What is plenary legislation? An act passed by the parliament or an act passed by the state legislative assembly, we call it as plenary legislation. The third category, subordinate or delegated legislation. Then challenge against policy decisions of the government. Then next category, challenge against administrative action of the government or statutory authorities. Or writ petition relating to criminal matters. Even FIR can be quashed under 482 under the previous code, and under 226 you can move writ petition to quash the proceeding. Justice Bajanlal case of 1992. Then public interest litigation. In all these matters, the grounds which you take or the extent of judicial review that is permissible vary from issue to issue. Now we will move to the next stage. That is, an amendment of the Constitution can be challenged by way of a writ petition. It's basically, challenge is confined on two grounds. You cannot say that amendment of the Constitution violates my fundamental right. No. Can you raise that contention? No. Only on two grounds a constitutional amendment can be challenged in a writ petition. One is, juniors may tell me, basic structure doctrine enunciated in Keshavananda Bharati case. I need not tell you the citation. Certain features of the Constitution are so fundamental or sacrosanct which could not be altered or modified by an amending process. Why? All authorities, including Parliament, derive its power from Constitution. An authority which derives power from Constitution must act within the four corners of the Constitution. Whether it is Parliament, our system of governance, it is constitutional supremacy. But in England, it is parliamentary supremacy. That is why you cannot. A short break, they want a
friends, it's already, our speaker told that it's very intimidating to see a senior sitting in front of him. So we thought that we will make a way out. We are humbly inviting our Additional Advocate General, Sri Ashok Amcharian, to hand over a token of appreciation to Sri T.B. Hood, because we actually wanted to do it at the end of the function, but then he made a statement that it's intimidating for him to see. അപ്പോൾ അതുകൊണ്ട് ഞങ്ങൾ അങ്ങനെ ഒരു ഗിഫ്റ്റ്, അത് കാരണം നമ്മളത് പറയുന്നത് ഇങ്ങനെ ഒരു ആവശ്യമായിട്ട് ഞങ്ങൾ ചെന്നപ്പം തന്നെ വളരെ സ്നേഹത്തോടു കൂടി അത് അംഗീകരിക്കുകയും അതെടുക്കാൻ വേണ്ടി ഒരു ശകലം സമയം വേണം, അങ്ങനെ ഒരു സമയം ചോദിച്ച് അത് പ്രിപ്പയർ ചെയ്ത് തന്നെ വരാം. അപ്പോൾ ഇപ്പോൾ ഇത്രയും കേട്ടതിൽ നിന്ന് തന്നെ നിങ്ങൾക്ക് മനസ്സിലാവും എത്രയും പെട്ടെന്ന് യങ്സ്റ്റേഴ്സിലേക്ക് കണക്ട് ചെയ്യുന്ന ഒരു രീതിയിലാണ് സാർ അത് പറയുന്നതും. അപ്പോൾ ഞങ്ങളുടെ ഏറ്റവും ഹൃദയത്തിൽ നിന്നുള്ള ഒരു നന്ദി സാറിന് കൊടുക്കാനായിട്ട് ശ്രീ അശോകം ചെറിയാൻ സാറിനെ ക്ഷണിക്കുന്നു.
ഡിവൈഎഫ്ഐയുടെ ഈ സംരംഭത്തിന് മുഴുവൻ ആശംസകളും നേർന്നുകൊണ്ട് ഈ ക്ലാസ് ഏറ്റവും വിദഗ്ധനായ ഒരു അഭിഭാഷകനെയാണ് നിങ്ങൾക്ക് കിട്ടിയിട്ടുള്ളത്. ഒന്നല്ല, നിരവധി ക്ലാസ്സുകൾ അദ്ദേഹത്തെ കൂടെ എടുപ്പിക്കാനുണ്ട്. എങ്ങനെ ഒരു നല്ല അഭിഭാഷകനാകാം എന്ന് പഠിക്കാൻ ഏറ്റവും പറ്റിയ ഒരു വ്യക്തിയാണ് നിങ്ങളെ ഇപ്പോൾ ക്ലാസ് എടുത്തുകൊണ്ടിരിക്കുന്നത്. അദ്ദേഹത്തിന് നിങ്ങളുടെ അനുവാദത്തോടുകൂടി ഞാൻ എന്നെ പറഞ്ഞുവിടാനുള്ള എൻ്റെ മാർഗം എന്നുള്ള നിലയ്ക്കും ഇതായിക്കൊണ്ട്
Thank you, sir. Thank you. It's all right. Constitution is also amended by a legislation, but it is not an ordinary legislative power. See Article 368. Article 368 says, in exercise of the constituent power. Article 368 is the article that confers power for amendment of the Constitution. Article 368 says, in exercise of the constituent power, that power for amendment of the Constitution is different from an ordinary legislative power of the Parliament or Assembly. But a constitutional amendment is not a law under Article 13. Earlier view was that a constitutional amendment is a law under Article 13. If it is a law under Article 13, what will be the effect? You cannot amend Constitution so as to modify or abridge a fundamental right. What Article 13 says, I initially told you, any law in conflict with Part 3 of the Constitution shall be void. That dilemma was get over in Keshavananda Bharati case, holding that a law amending Constitution under Article 368 is not an ordinary legislative process, it is a exercise of a constituent power. Then, I told you on basic ground of attack that can be mounted against a constitutional amendment is on what ground? Basics. Declared in 1975. Subsequently, it was followed in, I will just say the name, I have prepared a note as well as giving the citation, but I am sorry I could not give a copy to the organizers. I will give it to them. They will in turn give it to you also. Indira Gandhi versus Raj Narayan. That was 75 supplementary SEC page 1. Then Minerva Milk case 1980. Supreme Court Advocate Association record case 2016. 5 SEC page 1. That judgment related to amendment of the Constitution for incorporating National Judicial Appointments Commission instead of collegium system. Then recent judgment is Janhit Abhiyan versus Union of India 2023 that pertains to EWS amendment of the Constitution by 103rd Amendment. All these cases, either the petitions were dismissed or in some cases it were allowed, and the test applied was basic structure doctrine. And you have, when you challenge an ordinary legislation, never raise a ground that ordinary legislation is in violation of basic structure doctrine. that principle, that doctrine can be invoked only when challenge is against constitutional amendment. പറയുന്നത് മനസ്സിലാവുന്നുണ്ടോ? ഇല്ലെങ്കിൽ പറയാം. Basic structure doctrine can be applied by the courts, or you can request the court to struck down a legislation only if it pertains to constitutional amendment. Validity of an ordinary legislation cannot be decided on the touchstone of basic structure doctrine. Recent judgment, that is 2025 5 SEC 53 by Justice D.Y. Chief Justice Chandrachud in UP Madrasa Board case. This point was also considered. Then, the second ground based on which a constitutional amendment can be nullified is procedure under the proviso has not been followed. Article 368 says, with respect to certain amendments, you have to go to the state legislative assemblies and their ratification must be obtained. I am not reading out the article because of the time constraint. I am skipping that portion. I am not reading that. But if a constitutional amendment has been effected without following the procedure as prescribed under Article 368(2), it is a valid ground to declare a constitutional amendment as unconstitutional. By 97th Amendment of the Constitution, a new chapter was inserted with respect to cooperative societies. Certain provisions of those amendments were related to cooperative societies of the state also. So necessarily the amendment should have sent to the state assembly for their approval or ratification as required under 368. This was not done. So Justice Pardiwala, as his lordship then was a judge of the Gujarat High Court, in a writ petition filed by Rajendra N. Shah, declared certain provisions of the 97th Amendment of the Constitution as void as it violated the procedure stipulated under Article 368(2). The judgment of Gujarat High Court, I think it was Chief Justice Bhaskar Bhattacharya and Justice Pardiwala. It was challenged before the Supreme Court by the Union of India. In 2022-19 SEC 520, Supreme Court upheld the judgment of Gujarat High Court with certain modifications. Justice Rohinton Nariman wrote the main judgment and one other judgment by Justice K.M. Joseph also. There was slight difference of opinion as regards whether the entire amendment must be struck down or only certain portion which offends or which is in conflict or which is in violation of Article 368 should be set aside. You are aware of that principle, I hope. It is doctrine of, yes, that's doctrine of severability. If an order or a legislation or an amendment is in conflict with the Constitution, it need not be set aside in its entirety. It can be that operation of the judgment can be limited to the extent it is in conflict. You are severing the illegal part from the rest of the portion. So in Rajendra Shah versus, Union of India versus Rajendra Shah, 2022-19 SEC 520, 97th Amendment of the Constitution relating to cooperative societies were declared unconstitutional to a certain extent, not its entirety. And when you challenge a constitutional amendment or a plenary legislation, the prayer should be to declare the law as unconstitutional. Writ of certiorari cannot be issued against a legislation. Certiorari can be issued only in respect of administrative decision, government orders or administrative or orders passed by the other authorities. By a certiorari, you cannot quash a legislation. Let's say you may note down the judgment, that is, prayer should be declare the law unconstitutional. Prabodh Verma versus State of UP, 1984, 4 SEC 251 by Justice Balakrishna ARD. In that case also the prayer was to issue writ of certiorari against a legislation which Supreme Court said no. Then I will move on to the next stage, that is challenge against a plenary legislation. Any law in our constitution explicitly says any law in conflict with part 3 of the constitution shall be void. But there is no such declaration there was no such declaration in US Constitution. Still, in Marbury versus Madison, most of you might have heard about that judgment, 1803, Chief Justice John Marshall of US Supreme Court declared any law passed by the US Congress which is in conflict with the Constitution shall be void. The judgment was rendered in 1803. And High Court of Australia, which is the highest court in Australia, in Australian Communist Party case also declared, the foundational principle is this: a stream or a river cannot rise higher than its source. Got the point? A stream or a river cannot rise higher than its source. Parliament got certain powers from the Constitution. You cannot travel or rise above the power already conferred by the Constitution. This is what the Australian Communist Party case, High Court of Australia held in 1951. Stream cannot rise higher than the source. I told you earlier, there is UK courts do not accept challenge against legislation because there they follow. Somebody told me earlier, Parliament is the supreme. Whether UK has constitution, it has constitution. Who told you no? Every country has constitution, but UK constitution is not codified in one single document as in the case of USA or India. Lawyers of UK won't agree with you that if you say that you don't have a constitution, they say that it's not codified. Then when you challenge a legislation, you must keep in mind that there is always presumption of constitutionality. Every legislation is presumed to be constitutionally valid. That is why normally I have not seen any orders of the Kerala High Court or Supreme Court where a challenge against a constitutional validity of a legislation was admitted and interim stay was granted at the stage of admission. But a slight modification was made when 4 legislation relating to farmers, some orders were passed by the Supreme Court. But normally, when you file a writ petition and request for a stay, the court will not grant it. Why? There is presumption of constitutionality. There are 4 grounds to challenge a plenary legislation. In respect of amendment of the Constitution, we found 2 grounds. 1, basic structure, then non-compliance with the procedural requirement under Article 368(2). A legislation can be challenged, plenary legislation, if it violates fundamental right. Article 13 specifically says so. If it is in conflict with other constitutional provision. Article 13, what does Article 13 say? If it is in conflict with Part 3 of the Constitution. There are other provisions in the Constitution. If a legislation is in conflict or in violation of other provisions of the Constitution, still the court can declare that law unconstitutional. Third is beyond legislative competence. That's very important ground on which a law can be declared unconstitutional. There is federal distribution. Ours is a quasi-federal setup. Legislative powers are distributed between union parliament, state legislatives, and in the concurrent list. So when some legislations are made, it may fall within an entry under the other list which is not set apart for the parliament or state assembly concerned, then you can say challenge that this legislation is in effect referable to entry in union list, but state made legislation under an entry in respect of a matter over which they have no power at all. So it is beyond legislative competence of the state. One example I will tell. Certain under the central enactments relating to admission of students, postgraduate courses in medicine or other, if there is a central legislation and a regulation framed under the central legislation, state cannot make any legislation which dilute the standard. I stress the point, which dilute the standard fixed by the central government or central authority. What they do, under entry 66 or 68, they fix the minimum standards. Once that minimum standard is fixed, you cannot dilute the minimum standard. For admission to medical PG courses in the state, there was entrance examination, and central regulation mandated an entrance examination. State government came out with a legislation, state assembly passed a legislation that for in-service candidate, they need not appear entrance test. Their selection will be based on seniority in service. This was challenged by the other set of candidates, saying that this field is covered by a central legislation or a central regulation referable to an entry in the union list. So the state has absolutely no power under the state list or concurrent list to bring a legislation of this nature. That contention was accepted. So if it is beyond the legislative competence, it can be challenged and you can get a successful order. There is a striking difference may occur when the law is with reference to an entry in the concurrent list. In concurrent list, when it comes to concurrent list, union as well as state can legislate on the topic with a rider. What is that rider? Law made by the state. If it is in direct conflict with a law made by this parliament, the law made by the state, to the extent it is repugnant. That word has significance. To the extent it is repugnant to the central legislation or union legislation shall be void. So repugnancy arises. Many a times pleadings are drafted saying that there is, even with respect to legislation under central or union list, some will say that this is repugnant. Don't use the word repugnancy when you are challenging a legislation which can be referable to entries in the union list or state list. Repugnancy arises if both the legislations are in the concurrent list. When both the legislations are in the concurrent list and the state legislation is direct conflict and both the provisions cannot stand together, then the issue of repugnancy arises. How can we get over a repugnant provision in the state legislation? Correct. You have to send a bill to the assent of the president indicating that our assembly had come out with a legislation. This is in conflict with so and so provision in the central enactment. Please give us assent. If that assent is obtained, the question of repugnancy will not arise. But if it is a case of void legislation, in the sense, it is not something referable to entry in the concurrent list, but it clearly falls within an entry in the state list, union list, presidential assent will not save the legislation. I leave it there. Repugnancy, when we discuss repugnancy, there are certain other related doctrines also, which I am just saying only, pith and substance, colorable exercise of power. For want of time, I am skipping that portion. Then, fourth ground, which is recently added by way of judicial pronouncement, is manifest arbitrariness. That was clearly declared in Shaira Banu, that is triple talaq case, 2017, 9 SEC page 1, the fourth and last ground. Shaira Banu case, triple talaq, 2017. Then when validity of insolvency and bankruptcy code and related issues were challenged in Swiss Ribbon case, 2019, 9 SEC page 1. And in Puttaswamy Aadhaar case, I am referring to five-judge judgment of the Supreme Court, 2019, 1 SEC, page 1. There are two reported judgments, Puttaswamy. One is right to privacy. Larger bench first decided whether right to privacy is a fundamental right. That I think it is 2017 judgment. Thereafter, the matters were sent to the Constitution bench of 5 judges to decide whether provisions of the Aadhaar Act infringes the fundamental right of privacy. In that judgment, this is the five-judge judgment, 2019, 1 SEC, page 1. So, Puttaswamy Aadhaar case, for easy reference, you can say Puttaswamy Aadhaar case. Recently, in electoral bond case, Association for Democratic Reform, 2024, 5 SEC, page 1 also, this manifest arbitrariness principle was applied by the Supreme Court to decide the validity of legislation. Then two other judgments also, that is general grounds of challenge against legislation. I am referring only to the recent judgment, Binoy Vishwam versus Union of India, 2017, Jaya Thakur versus Union of India, 2023, 10 SEC 276. Malefites is a ground to attack a government order or a government decision. But you cannot challenge a legislation on the ground of malefites. Never allege malefites while you attack a legislation. Then I have already told you the severability, doctrine of severability. Then prior in a writ petition challenging constitutional validity, Prabodh Verma to 1984, 4 SEC. An ordinance promulgated by the president or the governor of the state is as good as a legislation passed by parliament or state legislative assembly. Any dispute? It has all the attributes of a law passed by the parliament, except the fact that it has not gone through the process of parliamentary system. But when the parliament or assembly is not in session and situation demands, governor or the president on the advice of the council of ministers can promulgate ordinance subject to certain conditions which we need not discuss for the time being. It is same as that of a legislation. So you can challenge an ordinance on the grounds on which a legislation could be challenged. That is 2017 3 SEC Krishna Kumar Singh. This is a very important judgment relating to ordinance making power. 2017 3 SEC Krishna Kumar Singh. So that portion is over. Then we are moving to the next stage. That is challenge against subordinate legislation or delegated legislation. And a legislation made in exercise of the powers conferred on the government or a statutory authority to frame rules, regulations, ordinance, statutes. We call it as collectively as subordinate legislation. For example, Kerala's KSR and SSR, you are all aware. There are certain statutory regulations framed by statutory authority. For example, Medical Council can frame regulations concerning the minimum standard required for an educational institution or the eligibility criteria for admission. It is also a subordinate legislation framed under an act by a statutory authority. AICT can frame regulation. Universities can frame ordinances or statutes. That ordinance of the university is not the ordinance under the constitution, it's an ordinance under a statute. Those set of legal documents we collectively call as subordinate or delegated legislation. All the four grounds which are available to challenge a plenary legislation can be invoked to challenge a subordinate legislation. In addition to that, there are two more grounds. One is, if the subordinate legislation is not in conformity with the parent act under which it is enacted. For example, if the Kerala University Act confers power on the university syndicate to frame regulation or ordinance with respect to certain matters, and the Senate or syndicate frame the rules or regulations beyond the power specified, you can say that this is not in consonance with the parent act. Third, last ground, is in conflict with other statute. A rule framed by the state government should not be in conflict with any of the existing other statutes. So these are the four grounds on which you can challenge, 6 grounds, 4 grounds which are already available while you challenge a legislation, additional grounds, ultra vires to the parent act, in conflict with other statutes. 2 judgment, Indian Express case, 1985, 1 SEC 641, and 2025, 1 SEC 641, Gaurav Kumar versus Union of India. It related to enrollment fees. Recent judgment. Gaurav Kumar versus Union of India. Justice Chandrachud, Justice Padiwala. I will read one paragraph from the judgment. Although delegated legislation enjoys presumption of constitutionality, it does not enjoy the same immunity as the parent legislation. It is now well established that delegated legislation can be challenged on the following grounds: lack of legislative competence, violation of fundamental right, violation of any provision of the Constitution, failure to conform to the statute under which it is made, repugnancy to any other enactment, manifest arbitrariness. These are the 6 grounds under which you can challenge a subordinate legislation. Then I am moving to PAL. To maintain a writ petition, you must be a person aggrieved and you must have a legal grievance. We call it as locus standi of the person to approach the court. The rigor of locus standi principle was diluted by the Supreme Court in late 70s and early 80s by accepting letters from the persons or by suo motu registering cases on the basis of newspaper reports. So the public interest litigation diluted the rigor of locus standi concept. Then, this is what a study report stated. PAL provide legal representation to previously unrepresented group. In the initial stages, Supreme Court accepted newspaper reports or postcards sent from the jail when persons were kept in jail for years together without trial. In fact, some persons have overstayed in the jail in the sense, if the trial was concluded and they were convicted for the offense they have committed, they would have been left from the jail years back. It was in that stage when letters were addressed to the Supreme Court or certain articles appeared in the newspaper, Supreme Court was prompted to take public interest litigation on suo motu. Main important cases, Sunil Batra case, Husainara Khatun case, Bandhu Mukti Morcha that related to Asiad bonded labor when Asiad was taking place in Delhi in 1984. And a prominent figure in the field of environmental law was M.C. Mehta. You all might have heard him. What are the parameters, or what are the circumstances, or what are the precautions that the court must take while entertaining a writ petition or while entertaining a public interest writ petition? There is a judgment of the Supreme Court, the very important one of quoted judgment, that is State of Uttaranchal versus Balwant Singh Chaufal, 2010, 3 SEC 402. I already told you that session. Now I am moving to the last portion, that's challenging other administrative orders, general grounds which you can invoke. Before that, I will refer to certain other judgments also with reference to the issuance of certiorari. Certiorari cannot be issued to quash orders of the civil court. Mirajkar case, AR 1967, SC page 1. Then Radheshyam 2015, AR 2015 SC 326 triad. Order of civil court is not amenable to jurisdiction under Article 226. In Bhajanlal case, 1992 supplementary SCC 335, power under Article 226 can be invoked to quash criminal proceedings. An order passed by government or statutory authorities like district collector exercising statutory power, you can challenge that orders on various grounds. One is illegality, irrationality, procedural impropriety, or in breach of legitimate expectation. Or you can say that there is violation of promissory estoppel also. I will briefly explain this. We are running short of time. I will briefly explain in nutshell. Illegal, if there is a legal requirement or a legal provision, authority acted in violation of that provision. Irrational. Irrational, when you say it is irrational, there is a classic judgment of the King's Bench, that is Wednesbury principle. Wednesbury principle, what is that? Irrational in the sense, no person with ordinary prudence would have reached that conclusion in a given set of facts. When you say that this order is irrational, you try to convey that no person with ordinary prudence would have come to such a conclusion in a given set of facts. One. Second, irrelevant factors were taken into consideration. Irrelevant factors were taken into consideration. Relevant factors were omitted to be consideration. These are the grounds or broad grounds which you can say when a document, when a order is attacked on the ground of irrationality. Procedural impropriety. Certain statute requires that some precondition must be completed before you go to another step. For example, statute may require that you should hear the other party before passing order. If that mandatory requirement of the statute is not complied with, it's a very valid ground to quash it. But in 80s and 90s, there were certain judgments which said you cannot attack an order on the ground of violation of principles of natural justice unless you establish by non-observance of the natural justice principle, you suffered an injury. But some judges have taken the view, failure of the authority to adhere to the requirement of natural justice by itself is a ground, even without any proof, additional proof of injustice or injury. It's still a debatable point. I'm leaving it there. I'm not going deeper into it. Then promissory estoppel. That's that we follow high tree case of English court, where the court said, if a promise is made which is intended to be acted upon and in fact acted upon, cannot be withdrawn. Promissory estoppel, in simple words, you can understand in this manner: an offer, a promise intended to be acted upon and in fact acted upon, cannot be withdrawn to the detriment of the person who had acted upon it. Okay, point pidigittiyo. That itself is a good topic to take 1 hour class, but for I am moving to the next. Then normally when we file a writ petition, judge will say that you have efficacious remedy, you have other efficacious remedy. Why can't you go to the higher authority under an appeal or revision? Existence of an alternate remedy is not a bar to invoke judicial review right. It is a judge-made, it is a self-imposed restriction. There is no such provision in the Constitution. Constitution does not say you must come to the court after exhausting the entire remedies available to you under the statute. It is a self-imposed, judicially evolved principle. But this principle is also subject, every legal principle is subject to exception. നിങ്ങളും കൂടി പറയണം. മനസ്സിലാകുന്നുണ്ടോ എന്തെങ്കിലും? ഒന്നും മനസ്സിലായില്ല എന്നാണോ? എന്തെങ്കിലും മനസ്സിലായെന്ന് വെച്ചാൽ ഒന്നും മനസ്സിലായില്ലെങ്കിൽ പിന്നെ അങ്ങനെയല്ലേ പറയാൻ പറ്റും. ഓക്കെ, existence of an alternate remedy is not a bar to invoke writ remedy in the following circumstances. 1, breach of fundamental right. If there is breach of fundamental right, you can approach the High Court even if you have an alternate remedy, but the court, whether the court may accept it or not, it's a second aspect. Then violation of natural justice. An order has been passed in violation of principles of natural justice without giving a notice to you. Relegating you to approach the higher authority in appeal will not serve any purpose because you could not place your facts before the original authority. So if the order was passed in complete violation of principles of natural justice, you can approach the High Court even if there is a statutory remedy. Order passed by an authority without any jurisdiction. If an order is wholly without jurisdiction, you can still approach the court even if there is alternate remedy. Third, last one, if you are challenging the very constitutional validity of the legislation, you cannot be told to go to the higher authority and raise this ground. Recently, when lawyer challenged, there was alternate remedy and still the lawyer challenged, I was present in that court, challenged the constitutional validity, and judge said, I was also a lawyer. When you find it very difficult to attack an order in a writ petition when you have an alternate remedy, the best method is to incorporate a challenge against constitutional validity. Sorry, dismissed. Then classic judgment on this point is 1998 judgment, Whirlpool case. It was related to a trademark registration withdrawal, that is Whirlpool case of 1998. Challenge against a show cause notice. Normally the court will not entertain a challenge against a show cause notice. Court will say that you go to the authority and explain your position. But you can challenge show cause notice if it was issued by an authority who is not empowered under the Act to issue the notice. 1. 2. If the notice itself is defective in the sense, does not disclose the reason which prompted the authority to issue the notice. I will explain. Government allotted some land in your favor. You got possession of the land, you are enjoying. Somebody filed a complaint before the authority, and the authority issues a notice. We have received a complaint that you are not eligible to enjoy this property, so we propose to cancel the allotment already made. You may submit your objection. Can you give an effective reply to that? The notice does not disclose what is the ineligibility. Notice only says we received a complaint that you are not eligible. Eligibility or ineligibility may be due to variety of reasons. Unless the reason is stated, how can you file a proper reply? So you can say that this is just an eyewash. This is not a proper shock cause notice. I cannot give a reply to this shock cause notice because the notice does not disclose the exact ineligibility, my ineligibility to get this land. So in that situation also you can. And the third one, as I said earlier, when you challenge the validity of a legislation under which the shock cause notice is issued, you can maintain writ petition against a shock cause notice also. Then normally we say that the order was passed in violation of principles of natural justice. It can be broadly divided into three. No man shall be judge of his own case. What? Hear the other party. And one more addition to the natural justice principle by judicial judgments is a reasoned order, a speaking order indicating reasons for the conclusion. Then, while hearing a matter or affording you an opportunity of hearing also, certain procedure or principles must be observed by the hearing authority. I will tell one example. There were two contesting claimants. Both of them were invited by the officer concerned for the hearing. When the complainant entered the office or the chamber of the officer, the other party was directed to remain outside. He was not heard. He could not hear he could not see what transpired inside. When the opposite party was heard, the complainant was asked to remain outside. Is it a proper hearing? No. These matters we must state with clarity in the pleadings. Unless you state it with clarity in the pleadings, you cannot raise it. So, hearing by an officer must be a proper hearing in the sense you must get a fair opportunity to explain your position and to hear what the other side alleges against you. Otherwise, you cannot give a proper, assume a situation when petitioner argues before the High Court and counsel for the respondent is requested to wait outside, and once he completes the argument, you are invited inside the High Court and the judge asks you to. Such situations occurred and the High Court intervened also. Then, order without reasons. Many times we see government orders or orders passed by statutory authority in 10 paragraphs running into 5 or 6 pages. They will explain this is what the case of the petitioner, this is what the case of the respondent. I considered the contentions of both parties and find no merit in the complaint. Whether it meet the requirement of natural justice. Does it meet the requirement of natural justice? Does. Why? Reasons for conclusions are lacking in that order. Unless you are told of the reasons by the authority on what ground he has rejected your complaint or allowed the complaint against you, you cannot challenge it before a higher forum. Second thing, when it is challenged before the higher forum or in a high court, the court will not be able to come to a conclusion whether the order is correct or not because reasons are not disclosed. Then, other grounds on which you can challenge an administrative order, non-application of mine, which is not a ground available to challenge a legislation or subordinate legislation. Then acting under dictation. collector passes an order as directed by the government when the government has no absolute power under the relevant statute. If it is a normal administrative exercise, you cannot challenge on the ground that it is acting under dictation. But the statute confer power only on the collector, and the government is nowhere near in the picture as per under the statutory scheme. Government is only an appellate authority, but the government directs the collector. We have received a complaint, we are forwarding it to you, you pass an order in the following manner. Then the collector does not exercise his statutory power, he is acting under the dictation of higher authorities. Then when you allege malefides can also be divided into two categories: malice in law and malice in fact. There is difference between malice in law and malice in fact. I will refer that one judgment. Ramjit Singh Kardam, 2020, 20 SEC 209. Malice in law is something done without lawful excuse. Malice in fact, actual malicious intent to do wrongful act. When an officer has bias or malice against you, and he purposefully with intention to harm your interest passes an order, it is malice in fact. But an act was done by an officer without jurisdiction, but not out of any personal animosity. You can say that it is malice in law. When you allege malice in fact or malefides against an officer, you have to implead him in personal capacity. Sometimes it occurs that an officer will be impleaded in as additional respondent in personal capacity, saying that he acted in a malefied manner. That is not sufficient. You must specifically indicate, specifically explain in the writ petition that he acted with malefides for the following reasons. You must state the reasons also why you are alleging malefides. Merely because he passed an adverse order against you, court will not infer any malefides. Malefides is easy to allege. It is said that it is easy to allege malefide, but it is very difficult to establish malefide. So unless you are very sure that there are materials to specifically make allegation, don't go for malefied, allegation of malefied. That may invite adverse observation from the court. But malice in law, when you allege malice in law, you need not implead the officer concerned. I can explain with reference to a recent judgment. Under the prospectus issued by the Commissioner of Entrance Examination with the approval of the state government for the KEAM examination 2025, there is a provision under clause 1.6 to amend the prospectus. So they have the power to amend the prospectus. But that power was exercised without adequate reasons. It is a malice in law. We are not saying that some government officer had some malicious intention. No, we are not saying so. But we will allege it is an action which offends or which attracts malice in law. Got the point? Then violation of Article 14, equality clause. There is no prohibition in Article 14 for a classification. But classification must conform to two requirements. It must be a reasonable classification, and this classification has a reasonable object nexus with the object sought to be achieved. So when two sets of people, when government comes out with a law or a government order, virtually classifying persons into two categories, you can say that this classification is without any reasonable basis. Assume that it has some reasonable basis. Unless that classification has some rational nexus with the objects ought to be achieved, that order will not sustain the scrutiny of law. So Article 14, classification, reasonable classification, nexus principle. Then, what Article 21, can anybody read? ആരെങ്കിലും ഒന്ന് പെട്ടെന്ന് വായിക്കൂ. So that I can have a glass of water. I will conclude in another 10 minutes. Nino is looking at me. 21 കിട്ടിയില്ലേ? ഞാൻ തന്നെ വായിക്കണോ? ആരെങ്കിലും ഒന്ന് വായിക്കായിരുന്നില്ലേ? വായിച്ചോ? Procedure established by law. Okay. If there is a procedure, your life and liberty can be taken away. Way back in 1950, one of the first major constitutional judgment of the Supreme Court in A.K. Gopalan was the state of Madras. This article was interpreted. If there is a statutory provision, legally passed legislation, your rights or liberty can be curtailed or limited. But over the years, we accepted some foreign principles also. It is not sufficient that there is a procedure. The procedure must also be fair, reasonable, and non-arbitrary. We call it, one is procedural due process, the other one is substantive due process. So unless the law meets the requirement of substantive due process, you can challenge that though the Act contemplates a procedure, it does not meet the requirement of fair or a reasonable it is not a fair or reasonable provision. Then hostile discrimination, fundamental rights cannot be waived. Can you waive fundamental rights? In which judgment it was declared by the Supreme Court? Olga Tellis, as well as in Olga Tellis 1985, Lombardy Engineering 2024 4 SEC 341, Lombardy Engineering. Then hearing by one person and order passed by another person, that's also a ground to attack. Sometimes you may receive a notice from district collector requesting you to appear for a hearing before the district collector. Instead of the district collector, one deputy collector may be assigned the duty to hear your arguments. He will prepare a note and he will present it before the district collector, and eventually district collector passes the order and he signs the order. Whether this is proper? Why? A person who heard the party must decide. When you hear a person, your doubts can be asked and clarified. That is why there is oral arguments before the High Court also. Otherwise, there need not be. We file a writ petition, with all pleadings, exhibits, our judgments are also given. Let the judge pass appropriate order. No, there is oral arguments. Argument was heard by one judge and reserved. He retired. Another judge takes up the matter and passes on. Is it permissible? No. Similarly, in administrative setup also, if a person was heard by one officer, he himself must pass the order. But there is an exception for this. When it comes to the hearing by the government and statutory authorities are different. As you district collector or commission of entrance examination or commission of sales tax, they are offices, individual offices. But when it comes to the level of government, it is an institution. Ultimate decision may be taken by the Council of Ministers, or sometimes it may be circulated to the governor also. So they all cannot sit and hear our arguments. So the principle, he who here must decide, will not apply to institutional hearing where the government is the authority to take a decision. Policy പറഞ്ഞു വരുന്നില്ലേ? To what extent policy decisions can be, even policy decisions of the government can be പറഞ്ഞിരുന്നു ഞാൻ. Policy, sometimes when I was also a government leader, I also raised this contention. This is a policy decision of the government. Court will say, so what? Policy decision is not immune from challenge on the touchstone of constitutional principles. If it is unconstitutional, if a policy decision is against a statute, act or rules, then it can be struck down. It has no special sanctity. Even constitutional amendment does not have such sanctity. Or plenary legislation does not have such sanctity. Of course, those plenary legislation, constitutional amendment, there is presumption of constitutionality, but still if they are in conflict with the settled principles of law, it can be. Similarly, even a policy decision can be interfered by the court on limited ground. But court, in economic policy matters, court give some leeway to the executive, because certain issues the court cannot step into the shoes of the executive and adjudicate. So on unconstitutionality, against statute, arbitrary, irrational abuse of power, court can interfere even with policy. When you in a writ petition seeking mandamus, it's mandatory that you must make a demand before the authority concerned, and there is inaction. If you directly come to the High Court without making a proper demand, unless the authority is reluctant or they are refusing to entertain, you cannot come to the High Court. Then I concluding, for a better drafting of writ petition, you must have, I will not say thorough knowledge, you must have an overall idea about various provisions of the Constitution. You must also know some idea, you must have some idea about administrative law. For lawyers who are practicing before the High Court, when we have to challenge government orders, better have some idea about rules of business of the government also. Rules of business of the government framed under the provisions of the Constitution. And certain books I will suggest for the young members of the bar who are interested for a deeper understanding of the provision, this area of subject. One is Wade on Administrative Law, WADE. It's a foreign book and a wonderful book on administrative law. WADE, Wade on Administrative Law. Then C.K. Thakkar, THAKKER, Administrative Law. Then Shorter Constitution by D.D. Basu. There is 11-volume book of D.D. Basu, which is not affordable. One thing. Second thing, for a practicing lawyer, it is not easy to cover the entire book. But there is Shorter Constitution in 2 volumes. They have come out with a new edition also. Then Judicial Review of Legislative Acts by Dr. C.D. Jha, J.H.A. Judicial Review of Legislative Acts. Two more books. Law of Writs by V.G. Ramachandran, publishers Eastern Book Company. Then Writ Remedies by Justice B.P. Banerjee, publisher is LexisNexis. These 5 books will help you to draft a good writ petition with appropriate grounds. And only on the legal aspects of the matter we can provide some information to you. As regards thinking process and drafting with excellent English and your imagination, these are all areas which you have to develop by yourself. No one else can help you. Thank you for giving me such a patient hearing. I am extremely grateful to all of you. I thank the organizers who have given me an opportunity to interact with you. I am sorry I could not complete within the time allotted by organizers. And I must confess that I have omitted some portions which ought to have been covered. But for want of time, I stop here. If you have, I will not ask whether you have any doubts. If you have any suggestions to improve my, what do you call, it's session, not a class, to improve what I have said in this room on this day, you can make your comments also. Thank you once again.
Especially if you have any, if you need any clarifications, please feel free to ask.
In camera proceeding. Already there are Supreme Court judgment which says we can discuss only. I cannot give my opinion on that. But there is Supreme Court judgment which says don't register criminal case against. No, you cannot challenge. You cannot say that a judgment of the court. Yes, I am coming to that point. You cannot say that a judgment of the court is in violation of fundamental rights. Mirajkar case 1967 clearly says you cannot challenge a judgment on the ground that it violates Article 14 or fundamental right. No. He may not get that benefit because they are holding constitutional post. Certain protections are afforded to them. Certain protections are afforded to them in the Constitution itself to maintain judicial independence. Supreme Court said otherwise. I can only say Supreme Court said otherwise. Okay, that's it. Already initiated. They enjoy immunity. Only when equals are treated unequally, you can say that. True, but person involved is not an ordinary person. He is holding a constitutional position. So we cannot say that it is violation of Article 14 in the sense equals are treated unequally. No. It's not a case of equals treating unequally. No.
Wholeheartedly appreciate the young lady who actually raised up to the occasion and answered the question. Thank you. So whereupon illegal, we will wind up the session.
Good evening, everyone. As we come to the conclusion of this insightful and enriching session, it is my honor to deliver a vote of thanks on behalf of the DYFI High Court Committee. First and foremost, I extend our deepest gratitude to our esteemed speaker, Advocate T.B. Hu, for sharing your expertise and knowledge. Your invaluable insights have significantly contributed to the success of this event. And a heartfelt thanks to all the senior advocates, young lawyers, and law officers who all are present here. To our dedicating organizing committee, thank you for your tireless effort and meticulous planning. A special thanks to all the attendees for your active enthusiasm and engagement. Your presence have made this event a collaborative success. In conclusion, thank you all once again for your participation. You have made this session a memorable and impactful experience. Have a great evening and thank you all once again.